This podcast series is part of the mission of the New York Intellectual Property Law Association, NYIPLA, Past Presidents Committee, to preserve a part of the history of our association and to provide continuity to our century-old association's values and traditions for future NYIPLA leaders. I'm Rob Rando, the current president of NYIPLA for the 2023-2024 term. Today, we are honored, and I am truly privileged, to have with us one of our most treasured members of NYIPLA, the Honorable Judge Pauline Newman of the United States Court of Appeals for the Federal Circuit. Welcome, Your Honor. And before we begin with any questions, is there anything you would like to share with us?
Well, your questions really seem to cover such a nice broad span. So I think let's talk, and then if there's anything else that we've left out, we can fill in.
Terrific, terrific. So as we begin, can you please share with us a little about your personal history before we get into questions about your professional life?
Well, I had a very ordinary middle class upbringing in New York City. I went to the New York City public schools. My father was a lawyer in New York, a sole practitioner, which apparently was not unusual in his day. And my mother taught in the New York City public school system. She taught English and art. And I just went about doing whatever it was that one did. Nothing at this point in my reminiscence comes back as any particular areas of crisis while I was growing up. I went to college in Poughkeepsie. I went to Vassar, which was again in keeping with the New York tradition. And uh, it wasn't until I think later on that if the word is evolved or developed into whatever has happened since and whatever is the person that I am now.
Oh, that's a great story. And I will say we have something in common, Your Honor. I'm a product of the New York City public school system as well. So this may be a rumor, but is it true that at some point early in your life, you learned to fly planes, drive race cars, and drive motorcycles?
Well, that's almost accurate. The Remember, I grew up. I was a child of World War II, and there was an enormous interest during the war and after the war in what was happening in uh, mechanics and in the evolution of whatever was happening. It was just the right time in the development of science and technology for all these things to be to be taking place. So yes, I learned to fly. Uh, my almost entire high school class uh, took flying lessons, soloed, and flew around in Long Island primarily. There were lots of very small uh, airfields, airstrips as well. So it wasn't that unusual in that culture. Also, it turned out that it was very interesting and lots of fun, so that I continued uh, well into my mature years with uh, with flying enough to keep my license current, to do occasional aerobatics. After a while, most recently, I take an instructor up with me if I want to do a few spins and loops in the air. The same thing with uh, sports cars. They were very much the culture, the immediate post-war culture. Uh, I had small cars. They didn't go very fast, but there were many opportunities for seeing what you could do. We all did our own tuning of the cars. You almost had to in order to get the extra half mile or mile out of the top speed of a four-cylinder car. So I had an MG, and I had a very small Jaguar, the XK 120, that I owned for a good deal of my, at least young adult life. As far as the motorcycle is concerned, I never owned a motorcycle. They were fun to drive. There was the wind in your hair and whatever else it is that is part of the appeal. And in those days, I was a skier. And so I would often go by motorcycle, by bike, with others to the Catskills or to Vermont for the weekends of skiing. So, to that extent, yes, those rumors are all true.
Well, you're right. It's so intriguing. I'm stuck on the spins and loops. That's amazing. Um, all right. Well, moving on to your professional life, what brought you to the patent world?
Well, I can't think of any answer other than that it was an accident. After I finished college, I went to graduate school. I studied chemistry at Columbia for a year, where I have a master's in pure science, but it was in chemistry, and then the PhD at Yale. And this was all very interesting. These were fascinating fields of science, particularly at that era where there was an incredible post war uh, growth, blossoming, I should say, of what was happening in science just because of the nature of the intellectual cycle that had been developed and that got a very large boost. Then, when I finished at Yale, I uh, took a job at the American Cyanamid Company as a research chemist, and I worked there for a few years. I uh, somewhat frivolously, after a few years, thought it was time for me to see the world. I don't think I'd ever been west of the Hudson River. And so I took a very prolonged vacation in Europe, in Paris, and came back, timed my return to arrive back at the time of the annual meeting of the American Chemical Society in 1954, it must have been. And they always had what they called an employment clearinghouse, and I signed up thinking that I would find a job that I really liked. And it wasn't quite that speedy. But one job that was offered to me on the spot was to uh, join the patent department of a chemical company, the FMC Corporation, and do what people in the patent departments do. Well, I knew what that was because in my research job at Cyanamid, I did have some patentable inventions, and I did work with people who wrote the patent specifications and proceeded with that part of your evolution. So I knew what I might be getting into, and it was crystal clear to me that this isn't what I was going to do for the rest of my life, or perhaps even for more than a brief transition, because um, because it would take a while, in my view, to see what was available, to find as well as I could the right position for the rest of my life as a research scientist. So I accepted the job, which was offered on the spot. I learned later that from the viewpoint of the people who did the hiring, I was the only applicant. So that made it easier. They need someone to come in and write patent applications. I knew that that was a job that people who were good scientists and capable of scientific research weren't interested in writing up someone else's invention. So that the scientists who were there at the meeting of the Chemical Society were not looking for this kind of job. So I took the job. I started right away, started the next day, sort of reorganized myself, readjusted to life in New York City, and found, somewhat to my surprise, that the work wasn't as uninteresting as I thought it might be. And meanwhile, through without very much of a plan, since I lived just a block away from the law school at NYU, I started to take classes there as well. And that was interesting. And time just sort of went on, and here I am.
That's a great story. And so early on, you developed your own personal and professional interest in patents and appreciation for the value of patents as was envisioned by our founding fathers, right?
Yes, that was instilled in me from the very beginning as to why we have patents and what they're supposed to be. They're not an award or a recognition of what you've achieved scientifically. That comes from your scientific publications and the all of the other aspects of the traditions of science and pedagogy. But the patent purpose is the industrial incentive, so that with the somewhat enhanced opportunity to make a profit on things that could be profitable, you develop new things, invest in research and development, and all of the rest of it. It's that aspect of patent systems that I think still remains inadequately understood by people who haven't really seen close up how intricately the patent system is intertwined with research and investment and commercial decisions and activities, and how the nation overall benefits from the innovations that thereby become available to us.
Absolutely. It's the driver of the economies.
Yes.
So, okay, so you were taking courses at NYU Law School, and then you moved on to practicing patent law. Can you tell us a little bit about that?
Well, I stayed with the same company uh, from the very, very beginning throughout as opportunities and promotions arose within the department as the uh, people who were running the operation either moved on or retired, and opportunities were offered to me, and I took to them. I had a superb staff who were, again, devoted and competent, and we did what our role was as lawyers and as scientists and as part of the corporate structure of the nation. I uh, learned more about a lot of things that I hadn't known very much about, and at the same time, I had good teachers, good mentors, and a very congenial uh, commercial environment.
So, how did you first become aware of the New York Intellectual Property Law Association, and when did you first become involved?
Well, I've been trying to reconstruct by looking back in the old files that I haven't looked at since I put them in a box and moved to Washington with the judgeship, and I couldn't really pin it down. The only thing that really comes to mind is that as a chemist, as a working scientist, I knew how critical the chemical societies and the American Institute of Chemists were to the advancement of the nation's interest in science. And the American Chemical Society essentially published all of the chemical journals in the United States. And there were the idea of congenial relationships, regular meetings, and educational and uh, friendly interactions with others in these fields was so much a part of the culture and so much a part of the people that you were. I was in graduate school that I first started participating in the work of the scientific societies, so that as to exactly how or who told me, by the way, there are similar kinds of activities going on in the law. I just have not been able to pinpoint. And I think the reason that I don't remember is because it was such a straightforward operation. There are organizations, and therefore you go to meetings, meet other people in your field, participate, and learn something. And so my guess, as far as I can tell, is that I heard about the New York then Patent Law Association, as it was called, uh, at the very beginning of my uh, patent writing activities. And of course, if there were meetings or whatever else, I participated. So I would guess that the whole thing really started very early, really quite a long time ago, probably while I was still in law school.
Sure. And that's a benefit even today for law students. And we are very active in engaging with law students very early on in their careers uh, with NYIPLA. I can tell you my first when I first became aware of NYIPLA, it was I was a first year associate and at Skadden, and the partner called me up. This was in 1989, and he said, "Hey Rob, there's this thing, there's patent prom, and rent the tux. We're going." So you recall um, when I entered the Waldorf Astoria, it was a surrealistic experience for me. Um, and if you don't mind, I'll share a little story about that with you. So we were, it was the first year for Skadden attending, and we were in the last row under the balcony. And during the course of the dinner, the partner leans over to me and says, "Hey Rob, we have to figure out how we could get up to the front row at this thing." And um, well, I said, "Forget that. I want to figure out how I get up to the podium." So, Judge, it's been over 30 years, but I guess I figured it out.
Yeah, that's not bad. 30 years uh, is about how long it takes, but uh, I'm glad that you're there.
Well, thank you. I appreciate that. So, talking about the judges' dinner, if you have one or maybe even more than one, can you tell us any favorite judges' dinner or patent prom or a favorite memory or memories from the dinners?
Well, I do have one memory, and uh, and I sort of brag about it because it puts me right in the middle of it. It was when the association uh, gave me their outstanding public service award, and I looked up the date. It was 2005, and so by that time I'd been in the business for 20 years, uh, and uh, the somehow tying it to public service hit a chord that I found very satisfactory. Nothing is quite simple in terms of the motivations that drive all of us to do the things that we do. But I remember that it was a beautiful event at the Patton Prom. It was at the Waldorf. There was entertainment. There was a singer who I think was an opera star. Uh, there was a very nice presentation. My acceptance talk was appropriately short, and everything about it was a culmination of all of the uh, elegant, I think is the word, procedures that always characterize the events of the New York Association.
Well, I will tell you, I have very fond memories of that dinner as well, Judge. Can you share with us with your trailblazing success as a woman in what was very much a male-dominated field in an overwhelmingly male-dominated profession, what it was like for you when you started out in the profession, and then reflect on your views on the progress that women have made in the profession, and even outside the profession with respect to STEM?
This is something that I had been starting to try to think about and understand because so many of the uh, problems and obstacles and all the rest of it that we hear about from not just women, but other minorities or people with other ethnic backgrounds or whatever else, and how there seems to be some kind of conspiracy that unless you're within a very narrow elite class, we're not going to let you in. And it's it's not simple. Uh, the only overall generalization that I can observe is that it certainly is very much of a different world than even a few years ago. Well, one of the things that it's gotten to be stylish to count is how many women are sitting at which council table and in which chair, in which court, and uh, how uh, how the proceedings recognize and acknowledge some sort of a hierarchy when it's apparent as to who maybe did the hardest work and who is there taking all of the credit. So there are so many aspects of human nature that apply. I think, in retrospect, that things were very much simpler in uh, in my era because there were very few women. There was no uh, pressure, organized pressure for recognition. Uh, Again, it wasn't the attitude, wasn't that uh, minorities of whatever source were ignorant or dumber or incapable. It was a matter of uh, assertion of dominance and authority of those who were already the insiders. Uh, we see other manifestations of this same human trait in the various nations where there are uh, dictators and dominant and subordinate uh, groups of people and origins and ethnic arrangements. And in part, I think I was lucky as well because the environments that one way or another I found myself in did not see women as competitors, didn't see women as people who needed to be uh, eliminated from uh, various opportunities so that the opportunity is available to others. And it spared me what might have been the turmoil of the battle, which started later and has, I think, been very effective. Is there can be absolutely no doubt, I think, of anybody, no matter which side one wants to be on, that the nation is better off with the broader intellectual participation of capabilities that uh, everyone who had previously been discriminated against uh, can bring to the nation. It comes back again uh, if the dominant national interest is in service to the nation is certainly so much better served. But as to my own personal battles, perhaps because, again, I was a child, I was in high school during World War II, the women were being uh, encouraged and more. This is the beginning, as I understand it, of many industries providing daycare for children so that the women could go to work as the riveters and building the machinery of war and without worrying about their children not having anyone to look after them. So that was, I think, historically the turning point in the combination of the appreciation of the intellectual changes in the culture, the technological changes, that it wasn't brute force and muscular strength, which was the most important characteristic. It was the intellectual ability and devotion that uh, that everyone has to varying degrees and can use based on their capabilities, based on their DNA, their intellect, and everything else that now we attribute our human nature to.
Well, that's a really well put description of it, Judge. And what you've identified is during World War II, it became a national necessity to be able to depend on the women in the country. Is that correct?
Yes,
Yeah.
yes, not just depend on, but to call on that there were resources here that uh, could be put to wartime use. The capability, I think, even when I was in high school, when I was learning to fly airplanes, nobody doubted that the uh, women were capable. And I wonder, when you said that you had gone to the New York City public schools, the schools did at the time I was there something that they had stopped, although I don't know exactly when. What they had done was that they, in the classroom, they set the students in a row based on their IQ tests. So that the person with the highest IQ test was in the first seat, and so on. And everybody knew that the first few rows of the classes were full of women and with a few blacks. And then the boys were sitting in the back of the room because they were dumber. And uh, again, that was considered discriminatory eventually, but at the time, it was easier for the teachers because if you had a tough question, you looked to whoever was sitting in the front row for an answer.
I love that. I love that. No, when I attended, what the way it was separated out was different classes were separated out based on capability.
Well, of course, that too, but it was quite specific. So nobody ever said that women were too dumb. It was the culture. It was understood and expected as I grew up that the women's responsibility was the family and the home, and that was a time consuming activity. And this was how the division of labor worked.
Sure. And then as far as the progress today, I'm a proud father of two daughters, both of whom became practicing attorneys. And my wife and I were very conscious of, making sure that they had the opportunity to be respected, to strive for whatever they wanted. But again, they also had the benefit of the evolution in the culture, recognizing everything that you've described. The important equal characteristics, although, based on the Y chromosome, maybe women are more equal. Um, so let's move on to your illustrious career on the bench. Beyond your science background and practicing as a patent attorney, how did you become involved with the formation of the Federal Circuit and ultimately, if I understand correctly, the first woman to actually be appointed to the court?
Yes, well, starting with the Federal Circuit, that was that era at which the Federal Circuit was one of the products, was a very interesting and difficult era for the nation. It was after the Vietnam War. It was after President Nixon. It was a uh, a time of sort of a combination. The nation was in serious recession at the time. If you look back now at the counts of technology advance, technological dependency, creativity, innovation, and industrial growth, the United States was fifth or sixth of industrialized nations, which put us, compared with where the nation had been after World War II, where we were the industrial survivor in the world, which showed how dramatically, for whatever reasons, and I don't know if anyone has figured out all of the reasons, but for whatever reasons, the nations had just lost its intellectual, uh, industrial, commercial leadership. And this was the area in which Jimmy Carter was elected president. And he formed a group at the president's level called the Domestic Policy Review of Industrial Innovation. He knew, as a matter of having been a businessman himself, and with all of the best advice in the nation, and understanding that meanwhile there was a lot of interesting stuff going on in technology. But even to the extent that some of it was happening in the United States, most of it was happening elsewhere. And the industrial development and leadership was happening in other countries. So we formed this group, this committee, this domestic policy review program of about, I don't know, 20 or 30 people who were the, as well as he could tell, the people in the nation who might be most likely to put their heads together and figuring out what happened, what went wrong, what was still going wrong, and what to do about it. For instance, some people thought that the Justice Department Antitrust Division was doing more harm than good. So the head of that division was a member. The head of the Patent Office was a member. A number of academics who had written scholarly articles on various viewpoints were members. The heads of several corporate patent departments were members. That was the path on which I was a member. The chairman of the committee for this review was Bob Benson, who was the chief patent counsel for Allis-Chalmers, but also at that time was the president of the AIPLA. And uh, a, a number of other people from all viewpoints were representatives of those who felt that everything should be shared and monopolies were bad and everything was too expensive. and every other viewpoint that you could consider. So we met fairly often in Washington and argued with each other. We commissioned studies of various sorts on anything that anyone could think of that could have an effect on industrial innovation in the United States, because the premise, President Carter's premise, was that industry was going to have to pull us out. Uh, you could do whatever you want with government, but somebody's got to do the work. And so we argued for a couple of years, and we came up with a lot of suggestions, uh, many of which have come to pass. Uh, for instance, one of the points that people were concerned about was, although the United States was supporting a lot of really good scientific research in the National Science Foundation, that the head of the NSF and others and people in industry would come and say, but it's just sitting there. Nobody would make these great inventions, not just in pharmaceuticals, but a lot of things that the NSF was working on, but industry won't touch it. And the question is, why won't industry touch it? Well, the answer, those of us in the patent business knew that industry wasn't going to develop it. If the next guy, the next day, could take what you developed, not having had the development cost, and undercut your price, and so on. So that was what led to, among other things, the formation of the Federal Circuit. It was not uh, really viewed as some of the most important of what we came up with. We had tax suggestions as well, and a number of things that happened. But it was very clear to us, I think all of us, that patents were not being appropriately reviewed in the courts. Some of the courts were okay, but some really had adopted and believed what one Supreme Court justice said: the only valid patent is one this court hasn't gotten its hands on. I can't remember which justice said that. Do you remember? But he gets quoted all the
I
time.
know the quote. Unfortunately, I don't remember which justice it is.
Yeah, I don't either, but it was in that era. And for those who knew that there had to be, that something had to change in the structure, and there were changes made, for instance, in the tax law and in others, uh, but that there had to be some dramatic, that there had to be a reliable patent system, and one that preferably got the answers right, because we all knew that if you weren't sure how it was going to come out in litigation, that wasn't any more of an incentive to invest than uh, if you, well, if you had more confidence. And the generally it was blamed on the differences among the various circuits. And we had all of the statistics that there was one circuit, I think it was the 10th, that hadn't sustained a patent in 80 years. And if you had any way of bringing your litigation, if you were against the patent in that circuit, well, it never went to trial because the other guy would give up. And that because you knew how it was going to have to come out based on the precedent in that circuit. So the idea of having one court was in combination with, at that time, the jurisprudence and the talent of the Court of Customs and Patent Appeals. There was Judge Rich, and there was Judge Markey, and the other judges who had sort of learned on the job that as to how the patent system should work, where the lines should be drawn. Of course, you can't go and take something that everybody knows about and patent it, but to know the rules and to know the rules are being fairly applied. So one of the suggestions of the domestic policy review was that all of these uh, patent cases go to one circuit court, and at least it would be settled in one. Even if it came out wrong, it would be settled. But ideally, we had this extraordinary, almost blind confidence that this court, as we envisioned it, with the people that we envisioned on it, would fix the law and get it right, uh, and would be respected by the Supreme Court, and that the stability aspect of innovation incentive would be resolved. So that's, and so all of that fit in with uh, my views and the views of every single one of us who was there on the corporate side, uh, as well as the others. And it some of the Congress people were either members of this committee or else they had observers listening, because it was intended, I think, by President Carter, that there would be some dramatic changes made, in which case there would have to be legislative action as well. So that's how I sort of got involved with the formation of the Federal Circuit. I was one of the disruptors who encouraged its formation.
Oh, that's tremendous background and quite a bit of foresight on the part of President Carter, and it gives me some thoughts. Um, I don't know if this correlates at all, but I know after the space race and we landed on the moon, as I was growing up, my perception is the excitement and interest in technological development kind of fell off a cliff in the 70s. I don't know if that had anything to do with it, but certainly looking at history and then looking at where we are today with respect to the patent system, I don't know if it's cyclical or in some way that we've come full circle with respect to the necessity for the strength of the patent law system, and arguably we're faced with the impediments for patent eligibility and so forth. And it just brings to my mind, I'm curious if you have any thoughts along those lines.
Oh, absolutely. That's the conclusion that I have reached, without any doubt. To try and understand how and why we have gotten to that stage is not simple. The nation has gone through these kinds of cycles every few decades, and as things start to go wrong and they need to be fixed. But that has been my perception, and now about the only area in which I have any opportunity uh, to interact, because I hadn't been going out and making speeches about how terrible the judicial decisions are and so on, because as a judge on the court, I need to keep myself as neutral for each new case that comes along as I can. However, uh, I have felt and acted on the belief that it's been my obligation, when I think my court has got something wrong, to say so. And it looks as if, I'm sure you know that my colleagues have removed me from hearing cases. I haven't heard an appeal since March of last year, and that it's perhaps I haven't been quite as polite in my dissents as I should have, and in my conversations about the role of the courts in understanding the patent system and its purposes and how it works. And I'm not going to go into any detail into all of this. Although it's certainly dominating my life at the moment, but the the actions of my colleagues to solve the problem by eliminating the critic is something that I am extraordinarily critical of, and am hoping, for the sake of the nation, to bring out. I appreciate that there are a lot of factors at play which seem to be coming together that are not doing our nation very much good at the moment. But I also feel that I am obliged as as a judge and as a citizen to do and say what I think is the right answer.
Absolutely, absolutely, Judge. And for what it's worth, I've been very active in trying to um, um, endorse patent law reforms over the years, including engaging with the Congress, um, and and I firmly believe that based on the genius of the founding fathers, that a stable patent law system is what was intended in the Constitution, and that was the purpose of it. If you look at the Federalist Papers, to make sure that there was a sound and stable patent law system that guaranteed the rights to inventors. So along those lines, Judge, we're in complete agreement, I believe. So let me talk a little bit about. I mean, we talked about the formation of the Federal Circuit and the goals that were intended. And do you think those goals have been achieved, and also how you think the patent system has benefited from having a Federal Circuit Court?
Well, in the first decade, at least, of the Federal Circuit, and maybe the first 2 decades, the at an era in which the uh, nation experienced a powerful turnaround, such that by the end of the first decade or so of the Federal Circuit, the United States had returned to position number 1 in the world in industrial innovation and growth, however it was being measured by whoever was doing the counting. And the Federal Circuit received a good deal of praise and credit for having stabilized the patent law, to have made it a combination of predictable. Of course, there was just one answer, only one circuit, so it wasn't as if there would be circuit splits, but that it would be predictably correct in implementation of all of the purposes, all of the rules. Of course, you don't want to say that that there are specific detailed rules that are suited for every area of technology or invention that might came up. But there was this great confidence and applause for the judges of the Federal Circuit in that they were getting it right, that they were interpreting the law as it was intended from the beginning, from the Constitution, and from the various statutes that had been enacted from the beginning. The flaw was not attributed to the enactments, it was in how the courts were interpreting them and applying them. But then it seemed that over the last 10 or 15 years, the courts, the Federal Circuit, has been slipping in its understanding or application for whatever reason. It's not easy to understand, and I certainly don't want to oversimplify what's an extremely complex sociological and all else aspect as educational and deeply held beliefs. But there's no doubt as to the result is adverse, in my view, to the national interest in the most profound, complex technological leadership. And now that wars are being fought with technology more than anything else, I would think that there would be even more reason for concern if, in fact, there are any disincentives or less than optimum incentives for technological growth and advance. So it's gotten to be pretty clear to me that it's time now for another major shakeup. And looking back in history, I know when I first came in, Judge Rich would always talk about the 1951 Patent Act as one of the major activities of the nation. And so we got in the habit of counting every 30 years or so. And so 30 years later, along came the Federal Circuit. And with all of the other things that were enacted, the Bayh-Dole Act, the Hatch-Waxman Act, the various tax law changes, and everything else that was done, an industrial innovation through that domestic policy review. Then, 30 years later, it was time, and we have the America Invents Act, a timely statute that is very complex and has a very mixed press, but the purpose to have an easier, cheaper, faster, speedier, and more reliable way of reviewing a patent because it was understood the complexities, the growth of participation in the patent system, and the difficulties in bureaucratically examining so many hundreds of thousands of inventions every year with all of the personnel problems and experience and all the rest of it, that for the few patents that really do require litigation, that there will be again, an expeditious way of resolving that. It seemed to me at the time, and I still think, that the motivation and the purposes of the American Invents Act were timely, if necessary, perhaps salutary. They haven't all been implemented by the courts, in my view, in the way that was presented to the legislators when they enacted the statute, which I think was somewhere about 9 or 10 years in gestation before it was enacted. So that the purposes there, I think, are unfulfilled. I have, in some of my criticisms of my colleagues, I have suggested that a different appreciation might be helpful. And so there's a lot to do. And I think it would not be remiss if, in fact, there were another major investigation of trying to understand, because technology is now so different that the old rules really don't apply in the digital world, in software implementation, discoveries. It's not a matter of anticipation and obviousness. They're totally different aspects. I must say, I'm encouraged that the copyright statute is filling gaps that were not initially perhaps intended for copyright law, and that there is time for a very hard, profound, and savvy look at the kinds of technologies that should be accommodated for the future and the optimum method of doing so.
I couldn't agree with you, Your Honor. I come back to the issue of patent eligibility, I think, is such, it's in such disarray, and it's actually been implemented counter to basic uh, federal litigation, civil procedure, and it's really impeding the incentive to innovate. That's just one of the contributing factors, and hopefully Congress is trying to work towards correcting that. I mean, I have my own views, and it's not necessarily the views of the NYIPLA, but I think we started down a bad road in eBay, and just various cases came along after that that just it's just exacerbated the problem of weakening the patent system. And I'm sure we could go on for hours about that, Judge, because we're in complete agreement on those issues. And by the way, I love all the dissents. I'll just throw that in there. Um, from your perspective, Your Honor, what is your greatest accomplishment or proudest moment thus far on the bench?
Well, I knew you were going to ask me that question, and I haven't been able to find the answer. I think that where I get my satisfactions, my pride, is the, I guess I'd call it thoroughness that I bring to every case, whether it's uh, an employment case or a whistleblower case where the appellant feels he's been mistreated and can't afford a lawyer and is nonetheless trying to vindicate uh, his uh, actions, or that trying to get someone to decide whether he was treated fairly or not, because there are statutes, plenty of statutes. The question is application uh, of of the statutes. So, but in terms of any uh, specific moment, I'm not sure. I suppose I should confess and say that whenever the Supreme Court adopts one of my dissents, we break out a bottle of that I keep for that purpose.
I love it. I
Of,
love it. I absolutely love that. That is so great, Judge. That's perfect. That's just perfect. Um, okay, so can you identify what has been your greatest challenge on the bench?
well, judges are not challenged. We we have a structure of, in theory, we're protected to say what we want. Uh, I am the first case since in 250 years that anyone knows of where a judge has been voted off the bench by her colleagues uh, for being grouchy or whatever it is that I'm charged with. And so I think the challenge now is one that nobody ever expected, a challenge to the independence of the judiciary. I think that this is one of the most important aspects of the, the foundation of our nation, the checks and balances among the branches of government, and again, the, the theory that the nation's judges will be free and unencumbered to speak their minds, uh, indulge their consciences uh, without fear of being punished by someone in higher authority somewheres, but are protected by the Constitution. Uh, Perhaps I'm not being as objective about all of this as I might because I'm in the middle of it. But it's if this is how the nation's judiciary is going to work, that an unpopular judge can be voted off the bench by the other judges on the same court, uh, and so far that's what's happened to me, then there is a fundamental assault on the structure of the nation and the strength of the nation that needs to be appropriately resolved.
Jack, are you with us? Jack,
Yes.
could you do me a favor and stop recording right now and let me know when you stopped, and then I'll tell you when to get back on?
So just pause the recording.
Yeah, can you please?
Yep, just give me 1 second.
We're almost wrapping up.
Yep, it's back on.
Okay, Judge. So, um, getting back to the New York Intellectual Property Law Association, what advice can you give our younger or newer members of NYIPLA if they aspire to assume a leadership role in the association and to get the most benefit from their membership in NYIPLA?
Well, you know, in some ways, that's a very complicated question because there is so much that can be done. I think that some young people, just as a matter of their psyche or personality, perhaps don't take to going out into the profession and making friends and becoming involved, and others seem to, just as a matter of nature, do all of this. I think that everyone who has participated in every organization knows that if they have the interest or time or appreciate the value of greater involvement, that they should work with committees, put in some time, put in some volunteer work, because every organization depends on its volunteers. Of course, the heaviest burden is always on the president, but one can only hope that the satisfaction of knowing you're making a contribution uh, is part of the justification, and part of it is maybe just doing the interesting things that uh, come along with the responsibility of administering such an organization. So, in terms of advice, it's the one word is participation, to within the limits and capabilities and interests of the individual person.
I must say, Judge, that your initial response to this, identifying the human nature aspect of individuals, it is so insightful, because you're absolutely right, right? The response is show up, right? Get involved, engage. You'll learn a lot. You'll be mentored. It will help you tremendously career-wise and personally. But pointing out that there are those of us who are very gregarious, and then there are others who, just by their own nature, are more reticent to assert themselves or get involved, right?
Yes, yes, and we really don't have to change human nature for people to get along in the world.
Well, truer words were never spoken. So, along the lines of advice, Judge, what advice can you give newer practitioners about practicing patent law and their interaction with the judges and the bench?
I would say that on the one hand, the extent that one engages in a practice that gives you satisfaction because you're contributing to the national well-being, that of course that cures itself. In terms of interaction with the law and with the bench, I would hope, and sometimes this takes a little bit of effort, that a primary consideration would be the integrity, the personal integrity of the person to do things right, to get things right, and the need for the greater need of the nation of practitioners who would be dominated by some nobler public purpose. It's always interesting to uh, to argue and to hear, particularly people who are successful litigators in close cases where there is a matter of skill. Often people are asked how they could represent some unpopular person or perhaps some murderer in before the courts, but the complexities of the rules of law, of humanity, of the processes of law, the search for justice, all draw upon some fundamental attitude of truth and justice. If the truth isn't going to help you, you don't have to incriminate yourself. But that doesn't mean that the case against you doesn't have to be proven either. So these are complex aspects, and with the study of law, and people, you see this among, starting with law students, as this kind of soul searching and the balance of the obligation to clients, the obligation to the nation, personal beliefs, in the family beliefs you grew up with, and all the rest of it, and how to reconcile all of these aspects if, because of a particular subject matter, they come into conflict. That the it still keeps coming back to me, to this, to be faithful to be faithful to the truth and to the obligation. But the laws, what's required of lawyers, whether in the patent field or any other, is a very complex and demanding aspect of humanity.
That's so profound. That is so profound, Judge. Right. And I often share this message with law students. I like to do a lot of work with law students and mentoring. And I tell them, there came a point in my career, and I always say I feel I should have known this, but I didn't. That the interaction with the judge in a particular case is really much more cooperative, and I didn't really fully appreciate that until I was actually appointed as a special master in several patent cases, mostly for Markman claim construction hearings, but also on a summary judgment motion. And I did realize at that time that I wanted to make sure I would get it right. And that's really what the judges want. They want to be able to get it right. I wanted to get it right for my appointing judge. I wanted to get it right for the parties. I wanted to get it right for the participating attorneys. And also I didn't want it, if my judge adopted my R&R, I didn't want it to be reversed by the Federal Circuit. And I always like to convey that message to the law students, because it truly is a cooperative exercise.
Yep.
So I'm still focused on advice. What advice, and we've talked about women in the profession and the evolution, but what advice can you give younger women today in the profession?
Well, I think the same advice that I've always given, and just to put it plain, I say, be smarter than anyone else. That's the first thing. And from then on, doors may open that won't open otherwise. That's that's not always easy for depending on what it is you're being smart about. But it does seem to me that women and all others who have been disadvantaged in the course of history are, uh, at least in the United States, uh, finally coming into our own.
That's great. So, Judge, as we wrap up this interview, do you have any other final thoughts you'd like to share with us?
Well, I've enjoyed our conversation. I observe that the association is again being well served by a very thoughtful president, and that uh, if we put our put our heads together and our activities together, uh, I think the goal of leaving things better when we finish with them than when we start with them is something that we all want to work on together.
Well, thank you, Judge, for those kind words. And I cannot express my gratitude enough for you sharing this time with us. And I've learned so much about history. Um, my father, God rest his soul, was a World War II veteran. So you've given me some insights about World War II that either I didn't learn in the history books or I failed to remember. Um, this is one of the highlights of my career, Judge, I must say.
Well, thank you for saying so, and I'd be happy for us to take up this conversation where we left off as things evolve.
Oh, that's wonderful, and I will take you up on that, Judge. This has been an unbelievably outstanding experience for me. Thank you so much. And on behalf of NYIPLA, I want to thank you so much.
And you,
Enjoy the rest of your day and have a great weekend.
and you too. Thank you.